The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's webinar, Best Practices for Employers on Teleworking. Before we get started, I'd like to go over a few items so that you know how to participate in today's event. You have one option to connect to the audio via your computer, and you will have the opportunity to submit text questions to our presenters today by typing your questions into the questions pane of your control panel. You may send in your questions at any time during the presentation. We will collect these and address them during a live Q&A session at the end of today's presentation. I would now like to introduce Jennifer Jackman.
Good afternoon, everyone. Thank you for coming. Tiffany, Peter, and I are happy to have everyone here and attending remotely as we deal with the issue of remote employees. So we're going to cover best practices for employers on teleworking today. First, we're going to talk about what exactly is remote working, because to different employers it means different things. The pros and cons of teleworking and remote working, what policies you should have for remote working, remote work agreements. If you're going to allow remote working, we recommend that you actually have an agreement signed by each employee who's participating in that, opportunity, the unintended consequences of remote working, and multi-jurisdictional issues with remote workers. And then hopefully we'll have time and we'll have some hypos at the end and then questions and answers. So we're going to talk first about setting expectations and minimizing risk for remote working agreements. And so what exactly is remote working? Well, there's a difference in some ways between remote working and teleworking. Sometimes people think of it as more of a temporary accommodation if someone's having a health issue and just going to work from home a couple days a week temporarily. But often the terms are used interchangeably. But as an organization, you can differentiate between the two or just pick the word that you're going to use, whether you're going to call it remote working or teleworking. Remote working, sometimes you think of that as being from the remote location, like the person does not live near the actual office itself, so they are working remotely. So if your office is in DC, perhaps they're working in Nevada. That would be more of the typical remote working. The telecommuting could be you work on site and off site. So some of your time is spent in the organization's headquarters or main office, and some is spent off site. The organization itself, though, can define which meaning it has and if you're just going to treat them both the same. So this is becoming more of an issue because, as Peter and Tiffany are going to cover, it may be a nice accommodation and benefit you're providing your employees, but at the same time, it can cause some unintended consequences. So we're going to talk a little bit about the trends, what's been happening in the workforce at large over the past several years, what are the pros and cons. So since 2005, remote working has actually increased by 140%. So that's a huge change in the way people work. A lot of it's generational. You'll have millennials coming in that don't necessarily want to work in the office all day, and they don't really care if they're making more money, but they'd rather have that flexibility. So you're seeing a change in the philosophy of your workforce. 3.2% of the overall workforce now works from home at least half time, and that's a big number. 40% more US employers are now offering flexible workplace options than they did 5 years ago. An employee who works from home half of the time can save the business almost $11,000 annually on average, and that would be from different overhead things and expenses like that. The employee themselves, if they're commuting, can save between $2,000 and $7,000 annually. So these are all some pretty big savings. And this is from Global Workplace Analytics, if you want to look at some more stats that they have. The benefits to remote working are in flexibility. You know, you can get some stuff done at home. It shouldn't be a deterrent or a distraction from your work, but it's kind of easy to have that flexibility in your own schedule and doing your other life balance issues. It can increase productivity, and you'll see on the cons, some of these are exactly inconsistent with each other, and we'll talk about why. It can lower employee stress and boost morale if done appropriately and correctly. It can decrease the costs like we just talked about and have a positive impact on the environment. Less people on the road, less pollution, less environmental change. It can also attract and retain more talent, including the millennials that we just talked about, as well as the older workforce. People who are allowed to work more flexible hours or remotely are actually more likely to stay on longer in the employment as what their life demands change as they get older. What are some of the cons to remote work? Well, the effect on your workplace culture. Sometimes you want a really integrated environment, and it's hard to keep everybody involved and feeling engaged if they're not all participating in the office. Morale, and where you can see that, I said morale could be increased by allowing it, right? But where it can be decreased is if people feel like there's a perception of disparity in how it's applied, if certain employees are allowed to do it and others aren't. A very clear example of that would be a receptionist. It'd be very hard for a receptionist to work remotely when they're there to greet people. And so that can affect their morale and seeing other people having flexibility that they can't. Also, inconsistent application if you're allowing the supervisors to determine it. So it may not be job specific, but supervisor specific. And so if one person has a more accommodating supervisor than the other, you're going to see some inconsistency there, and that could affect morale. Productivity. So on the one hand, I say productivity could be increased, right? But on the other hand, if the person is not accountable for their time, and you have to make sure it's the right dynamic to make sure that it really will increase productivity. If someone is spending less time on the road commuting, they have more hours during the day to work, right? So that will or should affect productivity. But if they're at home watching soap operas or not really paying attention and doing laundry and taking the dog for walks, then you might see it actually decrease in productivity. Engagement. So that's kind of with the effect on culture. If people aren't in the office at all, you have to be really careful at making sure you're still keeping them engaged, and maybe they still need to come in for staff meetings and things like that, and the accountability factor. So how as an organization can you balance the pros and cons and make sure that you're getting the best out of this scenario if you're allowing remote working? Well, the first thing you want to do is adopt the policy and make sure that you're applying it consistently. And in that policy, you want to define, like we talked about, what is remote working and what are the parameters on or the requirements that you have to fulfill in order to be eligible to remote work. You want to enforce it consistently. I see policies drafted where it is up to the supervisor. I think that that can invite problems because you can then have inconsistent enforcement of that policy. It may have a disparate impact on certain people. So I tend to not like supervisors to be the last say in that because some will allow it and some won't, and then that really affects your morale. Require remote work agreements that clearly define the expectations and the parameters of the arrangement. And in that, which we're going to talk about those policies and the agreements, it'll be very clear what the expectations are and that it can be rescinded. So when you're adopting your work policy, you want to define what remote work is and identify what positions are eligible. Is it a director level or higher? But what about the directors that are supervising people? Is it coordinator? Can anyone be eligible except the ones whose essential functions of the job actually require them to be there in person? Is there going to be a differential between full-time and part-time employment? Exempt versus non-exempt. You can expect that if you are having non-exempt employees working from home, you're going to have to really balance that out with what hours they're working, making sure they're still clocking in, that they're not doing work when they're not supposed to be. Some people don't allow any non-exempt employees work from home because of the risk of overhead and making sure that overtime and making sure that they're getting paid appropriately. So you're going to want to consider all of those things. Is there a minimum duration of employment? If the person just starts at the job, are they allowed to immediately start remote working, or is this something that comes as a benefit after a certain tenure at the organization? Satisfactory performance reviews. You probably don't want to have employees who are already not performing well in the office working from home. Because then that's when you get into what employees are accountable enough for their own behavior to be allowed this benefit. You also want to explain the process for approval in your policy, which again would involve or should involve having the agreement. And you want to make sure it's very clear in your work policy that A, it doesn't affect the at-will relationship of the employment, and B, it can be rescinded at any time with or without notice. So once you've gotten your policy and you want to have an agreement, what are the key provisions that you need to have? Well, first is going to be the nature of the arrangement. And so if you're going to have one type of agreement for all employees, it's really easy, but if it's going to change based on position, you just need to make sure you identify, is this a permanent or temporary accommodation? Is your policy typically that people don't work remotely, but it is an accommodation if medical needs require it, so that sometimes someone will come in and say, they're having a health crisis and need to work from home a couple of days a week. You would want to specify in the agreement that it's only temporary at that point. Are there specific days of the week, or is it flexible? Some of the problems I've seen people come up with the remote working is when the person has a flexible schedule and can change it at any time, or they take off Friday and Monday. So then, you know, they're really gone a long time, or it's always changing right before a holiday, or they're missing a staff meeting. So those are things you're going to look at. Is there a maximum on the days per week or month that remote working is going to be allowed? With regard to hours work, are there core hours they must be working? So you're going to want that to kind of mirror what your core hours are in your office. You know, just because they're no longer at the office, if you have expectations that your staff is going to be there between 9 and 5, then if someone's remote working, they should be at their desk between 9 and 5. And talking about the non-exempt employees and overtime, you want to make it very clear if they are allowed to work remotely that they are still prohibited from working overtime unless they get prior approval. And the days of the week we talked about when there are staff meetings, you might want to make it clear that if there's a staff meeting and it falls on a day that they're scheduled to work from home, that they are required to come into the office. What about your equipment? Who's going to provide the computer equipment, printer, and supplies? If you're going to provide any of that, you want to list that in there, and you want to detail who is responsible for repairs, for costs. Are they reimbursed by the organization, or are these employee costs? So maybe you're providing the laptop, but they're responsible for printers and paper and pens. Repairs, if your equipment is damaged, it should be handled in the same way as if it happened in the office. You want to specify exactly what is being provided. Security, this is often something that's overlooked. You take great efforts to secure your data in the workplace, right? And you probably have logins and all of those kinds of things. Think about from your HR perspective, if you're dealing with personnel files, they're typically going to be under lock and key. Well, if you're allowing HR staff to work remotely, you want to make sure they still have those same types of security measures at home if they're taking files home. So similarly, if you have if your employees that are not in HR deal with sensitive information, maybe it's your member list, it's things that you regard as very confidential, you want to make sure that you're covering the security issues there. You want to ensure the same measures that you require in the office are actually being adhered to at home. Your suitable workspace. So it used to be you have to have a separate office, you know, you'd get more of this was maybe IRS issues, but you would think to be able to work at home, you had to have your own separate office. Well, that didn't end up being the best idea because that could have a disparate impact on people who could not afford to have a separate office in their home. So you really want to just say a suitable workspace. It doesn't have to be a separate room that is only for the office. But you also want to make sure, again, that it's secure, free from distraction, things like that. The area must be safe and free from distraction and secure. You want to make sure it complies with OSHA, and we'll get into a little bit about the fact that you also want to be allowed to visit the office space if you ever want to. Now, I've never had anyone actually do that, but you just want to reserve that right. You don't want to just show up necessarily at your employee's house unannounced and say, okay, I'm here to inspect your workspace, but you want to reserve yourself that right and just remind them of the requirement to comply with OSHA. Prohibition of meetings in the home. That is a real big one. You do not want your staff holding meetings in the house with clients, with members, with sponsors, with other employees. So if they're going to have a meeting, they need to find a different location. It should not be in the home. You want them to require in the agreement the address so you know where that workspace is. And if they move, you just need them to update it. Part of that has to do with jurisdiction, and Peter, I think, is going to get into jurisdictional issues, but a lot of times your remote employees are working from a space that's not in the same jurisdiction your office is. I mean, if your office is in DC, you probably have a lot of your work staff that works in Virginia and in Maryland. And you want to know that because you could be potentially subjecting yourselves to the laws in those states. So you always need to know that current address, so you know where you have to register to do business and those kinds of things. At will, we talked about, you want to make sure that you're letting them know that even though they're entering into a contract, that contract is not affecting the at will nature of the agreement. Family responsibilities. So you want to make sure people who are using the remote working option are not trying to use that as a substitute for childcare or elder care. That's not what this is for. So just because they have a young child at home, that would not be the reason to allow teleworking, because at that point, are they actually now becoming the caretaker during work hours versus if they had a nanny? I mean, if they have a nanny taking care of the child, that's a different issue. But if it's because they don't have childcare and they want to be home, then that should raise a red flag. Does not mean that the employee cannot work from home if sick, but if they are too sick to work, then they should be too sick to take sick leave. You know, it's one thing if they say, I can still do the work, but I don't want to give everybody in the office my drones, right? That's one issue versus I'm so sick, I can't even keep my head out of bed, so I'm going to work from home. That's not going to work. Keep in mind that it's an employee benefit, and so the agreement should really be clear about the fact that this arrangement is solely for the benefit of the employee, that it's really not providing any benefit to the employer. And the reason for that is if you're ever sued, it can help protect you against a claim for asserting jurisdiction against you in another state. Because again, there's not a lot of research out there, but I have dealt with this issue for one client. And the more factors you can show that this was solely a benefit for the employee, the better off you'll be there. Termination, just to make it clear that it can be rescinded at any time at all, with or without notice. And with that, we're going to switch over to Tiffany.
Good afternoon, everyone. I'm Tiffany Relaford, and I'm going to talk about the unintended consequences of remote working. These are things that you may not think about that come up kind of after the fact, after you're already engaged in this arrangement. So one of those is understanding the impact of registering your company for employee withholdings in another state, the remote state, the state where the employee is located. You need to understand the applicability of employment laws in that remote state. I'm not going to get into a lot of detail on this particular area because Peter's going to talk about this later on at the end of the presentation. Also, you need to consider the relevance of handbook policies in remote states. Again, Peter's going to address that in his presentation, but if you're located in DC and you have states that pertain to employees working in DC, if you have an employee like Jen said working in Nevada or California, where we know they have some very interesting employment laws, you need to be mindful of that. Consider adopting supplements for different states to go with your handbook. Also be knowledgeable of tax consequences, and we're going to get into this. Sometimes state tax withholdings for remote employees in a particular state may be required of employers that have individuals working in those states. You may also be required to pay unemployment taxes in a state where you have a remote employee working. There may also be consequences if whether you're considered a single employee and if you're doing business in that state. So these are other things that can be complicated. And there could be a requirement to collect sales and use tax, depending upon the business that you're engaging in that remote state, as well as changes in a corporate registration. This gets into, are you now considered a foreign corporation because your headquarters is in one state, but you have employees working remotely in another state, depending upon what it is that they're doing. And could you be required to file corporate income taxes in other jurisdictions? Some other things to think about are compliance issues. In addition to what Jen talked about with OSHA, do you have to obtain and maintain a local business license, depending upon where you're operating? The other thing to think about, and Jennifer talked about this, is maintaining employee morale and inclusion. That's one of those things that could be hard or difficult, depending upon how many remote employees you have, as well as the ability to supervise remote employees and making sure that they are actually being productive and doing what it is that they're supposed to be doing while working remotely. So just to focus on some of these things, let's talk about changes in corporate registration. One of the questions to ask is, does the business need to register as a foreign entity in the remote employee state? This is going to vary state to state. So one of the things you're going to have to look at is, what does the business association statute of the specific state tell you need to do in order to determine if you need to register in that particular location? So if you haven't done that already and you have employees that are working remotely in other jurisdictions, that's where you should probably start in looking into that and seeing whether or not you have an issue. You must, though, register in the state if you are, quote unquote, transacting business in that state. And what does transacting business mean? It's really the common law definition of transacting business. So generally, there's some purposeful activity or act by which the business purposely avails itself of the privilege of conducting activities within another state, thus invoking the benefits and protections of the state's laws. So that's what you need to think about when you're thinking about whether or not are we considered doing business. And most people, if you're operating somewhere else, you may be considered to be doing business in that remote location. Even if you don't meet that general definition of transacting business in a remote state, you may still have to register your business in the remote state depending on that state's laws. Again, some states refer to this process as filing as a foreign entity registration or statement or applying for a business license. So this is when you really need to go in and look at the laws of those other jurisdictions in which you may be operating to determine if there are other requirements that you need to fulfill to have a remote employee working in that jurisdiction. One example of this is Washington State requires a company to apply for a business license in order to register for unemployment taxes, regardless of whether the company is transacting business in that state. So you may have an employee that they just sit at their laptop and all of their business is remote, relays back to DC where the headquarters is located, so they're not really transacting business. Because that employee is located there, they may still have to get a business license. Our recommendation is if you haven't already done so, make sure you contact an attorney in that remote jurisdiction regarding that state's laws so that you can determine whether or not you are in compliance and what you need to do to become in compliance with these issues. I can tell you from experience that most of the time our clients call us after the fact, after somebody's left and maybe they got hit with an unemployment claim or something else, and they're saying, well, we don't operate here, we just had somebody who's working here. And that's when you find all these loopholes and other things that you probably should have done ahead of time versus after the fact. So if you have an employee in a jurisdiction and you're not quite sure of what the laws are there right now, this is the time that you want to reach out to us or your contact there to figure out what you need to do to make sure you're in compliance with those laws. So briefly, to talk about state tax withholdings, this can be extremely complicated. And disclaimer, I am not a tax attorney, so putting that out there, but this is very complicated. So you need to make sure that you consult with the right professionals to get advice on this issue. Generally, employees are going to be taxed in their state of residence. But if there's adjoining states, sometimes there could be a multi-state agreement that provides that the other state will not tax the employee. So DMV area, most of the time you see multi-state agreements and that type of, those types of jurisdictions. Issues arise though if the state of residence is not an adjoining state. So the example we've used throughout, you're located in DC, somebody works in Nevada or somewhere else, clearly not an adjoining state. So you need to be knowledgeable about any sort of state tax withholdings. The question of whether the employee is physically present working in the remote state to a degree that both states will impose tax withholdings. That's another question that could arise where maybe they do work 50% of the time in both areas, both jurisdictions, I should say. For remote employees in non-adjoining states, the general rule is to withhold taxes in the state where the work is completed, which is generally called the physical presence rule. So wherever they're physically working, that's generally where you're going to tax that employee. But again, this can be complicated if the employee works in many different states. So when we talk about unemployment taxes, regardless of whether the business will have to register in a remote state, they may still have to pay unemployment taxes in a remote state where an employee is working. The test that's used to determine if an employer is required to pay unemployment taxes in a particular state is the localization of employment test. And we're going to go through this test. It has 5 factors, and an employer has to go through each factor to determine where they need to pay unemployment taxes. So just starting with the first factor. The first factor is going to be where are the majority of the services? Are the services localized in some way? What that means is services are localized if the remote state, in the remote state, if the employee performs the majority of the services in that state. If the services are performed in other states, the services are considered incidental or temporary in nature. So that's the first test. If you don't meet this factor, then you go to the second factor, which is base operations. Under base operations, the employee's services are localized in the state in which base of operations is located if the employee performs some of their services within that state. So let's say you've gone through 1 and 2, you don't meet 1 and 2. So now you go to 3. 3 is going to look at direction and control. If tests 1 and 2 and 3 do not apply, but there is direction or control in one of the states where the employer performs services, then the entire state should be reported to that state. Direction or control refers to a facility from which the employer can exercise immediate control of the employee's services. So here we're looking at, where is your base operations and your headquarters located, and can I exert control over that employee if I can't meet any of those other factors? If all else fails and that still doesn't work, then you're going to look at where the employee lives. Where do they reside? Where is it that they're actually working? Because at this point, none of the other factors apply. The employee's services are localized in the state in which they reside if some of the services are performed in that state. This is probably the rarest one that most employers use, because most employers are going to fall in one of the other factors that came before on number 4. And there's also, again, if all else fails and you don't meet the other ones, then services are not localized in any state. If you don't meet any of those factors, then now the employer has a decision. And what that is the employer can either elect to file within any state in which the employee performed some service to cover the employee's entire services in that state, or report a proportionate share of the employee's earnings in each state in which the employee performs services. This is when you probably want to consult with an accountant or someone else to make sure that you are reporting those taxes properly. So what happens if the employer misapplies those factors? Well, the main consequence is then you could be overpaying state unemployment taxes in the different jurisdictions where you may have remote employees working. An example of this is if you have an employee that performs services in 4 states within a single calendar year, and the employee earns approximately $15,000 in each state. If the employer pays state unemployment insurance in each state in which the employer performs services, the employer could pay 4 times the required state unemployment tax. So that's why it's important to know, where do I really have to pay these taxes to, and how much should I be paying to avoid these overpayment of unemployment taxes, especially if you have more than one employee working in several different remote locations. And now I'm going to turn it over to Peter.
My name is Peter Guattari. I'm a partner with Whiteford, Taylor, and Preston in the Baltimore office, where I've been for about 32 years. Started when I was about 11. Anyway, so what I'm going to talk to you now about is multi-jurisdictional issues and the issues that can come up when you have employees working in various. I'm going to cover a variety of laws that I have personally encountered dealing with clients over the years, and usually at the last minute when you find out something is wrong, and sort of give you some guidance ahead of time so you can think about it. Know where they are and what laws might apply, and know what potential issues could come up, and be prepared for them, rather than call me up and complain because you tell me you had employees there and you just got hit with a notice of assessment from California for $15,000. So the first question is going to be, whose law applies? And really the general rule is that the situs of the work is going to determine the applicable law. It's where that employee happens to be sitting. In all likelihood, that's going to be the applicable law that's going to be considered for what benefits that employee gets under the state law, what termination provisions there might be, what discrimination law might apply, etc. You can try, and some clever attorneys have tried to claim, I got a choice of law provision in there. I got this law, my contract says that Maryland law applies regardless of where you are. That might get you this far. Because when you're dealing with employment statutes, often the statutes that are going to affect the employee's terms and conditions of employment are public policies of the state, which is a perfect way to overrule the law provision that there's public policy within the state to say it's not going to apply. So even if that employee doesn't regularly work in the jurisdiction, in a particular jurisdiction, they may have sufficient contacts with that jurisdiction, so that law may apply. I'll get to an example of that in a minute, but you might find somebody maybe working in Maryland, but they may be calling the DC law might apply to them. I'll give you an example. Real case, not my case, thankfully. Employee worked in, employee and her supervisor worked in Virginia. Corporate office was in Virginia. Company did not do business in the District of Columbia, but the employee's supervisor would bring her regularly to his apartment in Washington, D.C., where they engaged in he said consensual, she said not, affair, and she brought a claim with the D.C. Office of Human Rights. And there were no other contacts with the District of Columbia other than that affair. And the D.C. Office of Human Rights asserted jurisdiction over it, and the D.C. Superior Court upheld it and said that there was sufficient context because the conduct occurred in the District of Columbia, and therefore the law covered it. So that's just one terrifying little example, particularly since the difference between the EEO laws in Virginia and those in DC are substantial, particularly if you've ever been in the laws of the DC Office of Human Rights. And with a multi-state workforce, your policies are such, you're going to need to recognize those differences in law and make adjustments for those variations in law. Okay? That means it's going to have to be in your handbook somewhere, or you're going to have separate policies that you provide to those employees who are remote that relate to that specific state of employment where they happen to be located. So let me give you one example of multi-jurisdictional problem. DC Sick and Safe Leave Act covers any employee who spends more than 50% of their time working in DC. The employee spends less than 50% of their time in DC but doesn't work in any other state for more than 50% of the time. DC is their primary place of employment for the DC Sick and Safe Leave. Montgomery County has a Sick and Safe Leave Act too that covers any person who regularly works in the county for more than 8 hours each week for an employer that employs one or more persons in the county. I had a client who actually had this. They had an employee who worked in both jurisdictions. What benefits does the employee get if they work 45% of the time in Montgomery County and 55% of the time in Washington, D.C.? The answer is both. And you need to account for it and be very careful to make sure that your policies are going to provide those benefits, because there may not be huge differences between the laws, but there are some differences between the laws that you need to take note of. So what are the common area concerns that we have? Final paycheck laws, vacation pay on termination, leave benefits mandated by state and local laws, non-competition agreements, sexual harassment. Those are the 5 key that I see repeatedly. The top 2 more often than the other ones. But there are others, okay? There are others that you're going to come up against, and it's best to know, you know, what those are. You'll be happy to know that at-will employment applies in all 50 states, so you don't have to worry about that. Doesn't apply in Canada, and Canada's not a state, so if somebody works in Canada, keep in mind it's a different country and it's a different jurisdiction. I've had to explain that before, believe it or not. Final paycheck laws, what are we looking at? Well, I always hear, oh, we'll just send out the paycheck on the next payroll day. Bad idea. DC law, as you probably know, requires terminated employees be paid by the next working day. There are some exceptions, but that's the general rule. In California, the state we love to point the finger at and say, if you're going to do business there, you need a lawyer, probably a couple of them. California law provides that final pay has to be paid immediately. And what are the penalties? A day's wages for every day that you forget to pay the wage or neglect to pay the wages for up to 30 days, okay? And if you have a highly paid employee, that's a lot of money. And I had an employer call me where they got a $15,000 assessment from, I think it's the California State of Industrial and Labor Relations or something like that. And you'll pay that penalty with maybe a modest reduction. So it's very important to know what the laws are going to say in those various states. California isn't the only one that says that you have to pay immediately. So you need to keep that in mind. Final paychecks, what's due? Keep in mind the definition of wages can change from state statute to state statute. What's included, what's not. Bonuses and commissions, the terms of the commission and how it's earned might change. What's a bonus and whether it's actually a bonus that's due as wages might change under state law. And typically these are defined in your contract, but if you do have a contract for specifically or in particular for commissions for an employee in a different state, then it's important that you check with that particular state to see what the requirements are and whether the contract that you have is consistent with state law or whether there's something that would allow you to enforce that contract regardless in that state. Because that is an issue that I've dealt with just recently with someone who had a commissions policy that didn't comply with Massachusetts law. And we had to rework the offer letter to be more compliant using a Massachusetts attorney who was familiar with a statute, which I kid you not is a single sentence for 2.5 pages. And I didn't even know how to read it. I think it was originally written in Latin, translated into German, then put back into Old English, and then was translated into probably about 1625, just after the founding of the Bay Colony. And so it was a really complex law and wasn't something that you could readily figure out just by looking at the statute. And the other issue that comes up is payout of unused accrued vacation, and whether those state laws mandate it, like in California, where vacation pay is earned comp and can't be forfeited. And you need to make sure that the state where your employee is doing business or is working remotely, that law is what that law is with respect to vacation. So the other thing that you're going to find is that state and local sick leave laws vary widely. They might make a differentiation between paid and unpaid. Maryland requires both, up to 15 unpaid, over 15 paid. Some states only set a limit of maybe 15 employees paid. Under that, nothing. So you need to look carefully at that and adjust your policies accordingly. One of the things you should look at is what's the definition of employer and employee under the statute, because they might affect whether or not having one employee in that jurisdiction makes you covered. In many states, the answer is yes. You might be covered as an employer, but the employee may not be covered, or you may not be covered as an employer because you don't have the requisite number of employees. How much leave is required and how does it accrue? This is where you see the most variation in terms of the number of hours that accrue and what's the accounting for it. Most of them have an upper limit that's somewhat similar of 40 hours, but not all. May time be carried over? Any workarounds? Any of you have tried to figure out the carryover of leave under Maryland law and how it's written? You know what I'm talking about in terms of the difficulty of applying it. So looking at that and structuring your policy accordingly is important. And what the leave may be used for. Generally, they're similar. DC and Maryland law are similar. Montgomery County has a few exceptions, and that is where you get a local version, where the law is different. And particularly if you have an FMLA. In DC, you have a FMLA policy that's very distinct from federal law. Maryland doesn't have one, but some other states do have similar FMLA policies. And like I said, beware of the local laws. In California, there are at least 3 jurisdictions that have sick leave laws which differ in material respects from the California sick leave statute. The California statute is up to about 5 days, and some of the, I think San Francisco has up to 96 hours, which is significant. In Maryland, the Montgomery County Sick and Safe Leave law was specifically grandfathered by the Maryland Healthy Working Families Act. And New York City recently enacted its own sick leave laws, even though there's no specific leave requirement in the state. So you may say, New York law applies, there's no sick leave, you don't have to worry about it. But you need to know what's going on in New York City, particularly since New York has been very active recently in putting in certain types of wage and hour legislation, sexual harassment legislation, and sick leave legislation. So being aware of the local jurisdiction is important as well. And that brings us to non-compete agreements. Numerous states have laws which govern non-compete agreements. You might think, here I'm located in the District of Columbia, we have a common law test that applies. We know what those standards are. We've got our lawyers wrote us one. We're going to use that in every state where somebody does business. That's not necessarily going to be true, because states like California and Massachusetts and Georgia, just as examples, have their own laws which strictly limit non-competes. And they're going to address issues such as consideration and the scope of the restrictions and limit them. Okay? In California, for example, as I said, the use of non-competes is severely limited into very specific narrow categories. And in some states, such as Massachusetts and Idaho, the law limits who may be bound by non-competes. Generally non-competes. You know, as a rule of thumb, generally, you say the janitor can't really be on a non-compete. But a lot of employers like to try and get more hourly employees or other rank and file employees to sign off on non-competes. You're going to have an issue with that. So let's look at Massachusetts, which just had a law that went into effect on non-competes. And this is interesting because this may be a precursor to laws that you see coming down the road in the future to limit non-competes. Just became effective last October. Agreements have to be narrowly tailored. They have a 12-month limit. Okay, but we're talking about non-competition agreements. Okay, the statute draws this distinction between confidentiality agreements and non-solicitation agreements, which are not covered by this law, and confidential or non-competition agreements. So right there, you've got some room to tailor a scope of protection for yourself and your clients if this employee goes off to a competitor that wouldn't be covered under this law. But if you truly want to have a non-compete, you're going to have a 12-month limit. Okay? The law specifically says that there are no agreements for non-exempt employees, student interns, and no-cause terminations. So even if you have a non-compete with somebody and you fire them because you just didn't like the way they looked that day, that's a non-cause termination. You're not going to be able to sue to enforce your non-compete, even if it was validly entered into. And the other thing that's curious about Massachusetts is they put into effect the strict consideration requirement. And non-competes must be supported by garden leave or other mutually agreed upon consideration. Now, garden leave actually comes from English law. It's an English law concept that, you know, you have to pay the employee. If you want to restrict them post-employment, you're going to have to pay them something. And the concept is that the employee would then be able to enjoy that pay while sitting in his or her garden, okay? Which, by the way, is a yard. Okay. So that's a fairly well understood concept within English law, and it's interesting to see that they actually brought this into the Massachusetts law. And how they did it is garden leave must be paid on a prorated basis for the duration of the non-compete period, must comprise at least 50% of the employee's highest annualized salary paid by the employee during the last 2 years of employment, and may not be unilaterally discontinued by the employee absent a breach. So that's 50% of their pay for 6 months. Okay? And you say, good God, that's a lot. Well, you can also use other mutually agreed upon consideration. And what's interesting is that doesn't mean garden leave. It doesn't have to be equivalent to garden leave. And that's clear from the commentary on the Massachusetts law. But what's not clear from Massachusetts law is what that actually means, because I've talked to 2 different lawyers and got 4 different answers as to what it specifically means. I've seen some commentaries that can say it can be 10% of pay, and others which, excuse me, say it should be something higher. So that's an issue that is out there and probably is going to need some lawyering to sort of figure out what might work. And the other thing that's important about Massachusetts law is that non-competes executed after hire must be supported by fair and reasonable consideration, independent from the continuation of employment. Now, you know, in this jurisdiction that continued employment may well serve as a basis for enforcing a non-compete entered after employment has already started. And the reason being that you say, sign this or you're fired. That's not going to work in Massachusetts. You're going to have to give some other type of acceptable consideration under the law. So let's talk about the last one, which is harassment law. In the wake of the Me Too, a number of states enacted strict sexual harassment. New York City, for example, New York State, I'm sorry, mandates training as well as specific terms in the sexual harassment policies, such as advising employees where they may file complaints for violations of the law, and requires you to give the employees a complaint form. Okay? If you have somebody in New York and you haven't complied, go to the website for the State Department of Labor in New York. They have, excuse me, pages that deal with this that will be helpful to you along with a model policy and getting into compliance. It applies even if you have a single person there. Several states have banned confidentiality provisions in settlement agreements relating to harassment complaints. Under Maryland law, an employee may not waive any substantive or procedural right or remedy to a claim that accrues in the future of sexual harassment or retaliation for reporting or asserting a right or remedy based on sexual harassment. What's interesting about this statute is the question of whether this limits the arbitrability of sexual harassment claims under employment agreements. That is an issue of potential preemption by federal law under the Federal Arbitration Act. It has not been decided. It has been raised a couple of times, but it is something to be aware of if you have arbitration agreements that you might find yourself in, that Maryland law may make that, or at least on its face, invalid. So we're going to come up to extra knowledge.
Okay. So we have a couple of hypos for the group. The first one is XYZ Corporation has a remote policy that states that employees who are on a performance improvement plan are not eligible to work from home. Fran has been with XYZ for 3 years. For 2 years, she performed well. During her 3rd year, her performance declined. She's now on a PIP. She comes to you and explains that her performance has been impacted by her father's health. He moved in with her and she is the primary caregiver now. His health has recently declined even further and the costs of private nursing are becoming a burden. She asks whether she can work from home 2 days a week so she can reduce her costs and only pay for caregiving 3 days a week. What do you say? Any concerns there? Yeah, there's probably a couple of concerns, right? So, you look at, is this an accommodation? Well, it's a caregiver for her father, so that's really not going to allow her. That's where we talk about you don't want it to be a substitute for health or for elder care. So she's already ineligible under the PIP. She's now told you there might be reasons for the performance improvement plan that she hasn't disclosed before, but you don't want to allow the remote working as a substitute for elder care. It's certainly not going to improve her performance at home. So I would say you probably want to decline that request. Yes, that's an excellent point. FMLA, at that point and I meant to say that, I'm glad you reminded me of that. That would be a good time to say if this is a serious health condition that her father is having, that maybe the one option would be either some sort of FMLA so she can get that under control. The next one is ABC Corp has a policy that only exempt employees are eligible for remote working. As it turns out, most of the exempt employees are male and non-exempt employees are female. Any concerns? So here's a standard, you're applying it consistently. Any issues? Yeah, there could be some issues there in disparate impact, right, on a certain protected category of employees. And so in that situation, you'd really want to look at that and say, what's the reason for not allowing the non-exempt employees to work from home? Or is it because the essential functions as seen in their job description, and make sure that that job description is up to date and accurate, are they ones that can't be performed remotely? Or is it more of the concerns with reporting, and do you have technology that would allow you to make up for that? But you would certainly want to reevaluate how you were applying that policy. XYZ Corp has a remote policy that leaves the decision to work remotely to the discretion of the supervisors. We talked a little bit about this earlier. Some supervisors allow it and others do not. Any concerns? Yeah, that's going to be that consistency of enforcement. And again, it could be a potential disparate impact. And even if it doesn't result in there, it could be a morale issue and a culture issue, because now you're going to have different departments that may seem divided because some are afforded opportunities that others are not. ABC Corp has a policy that only allows employees to work from home 1 day per week. Flynn has been working from home 1 day a week for 2 years. Finn has recently been diagnosed with cancer and has treatment 3 days a week close to home. Finn comes to you to ask whether he can work from home 3 days a week on the days of treatment because the treatments make him tired and the commute into the office will zap his energy. He says he'll be more effective if he can work from home those days rather than using up his energy on the commute. It will also allow him to take periodic naps during the day if need be. What are your thoughts on that one? A little different than the one who wanted to care for the sick father, right? So in this situation, I would say you'd really want to consider this as a reasonable accommodation, right? If it's an issue with a disability, assuming the cancer would be considered a disability in that situation, and it's, he can get the work done from home, you would want to consider that request. And even if he's taking a couple of naps a day, again, if you had an employee at work, one of the accommodations requested might be breaks in order to rest during the day. So you'd want to consider that. You could always require documentation from the doctor so that your file is nice and neat, but that would certainly be one you'd want to consider. I think that was it. And now we've got Q&A. Tiffany, did you want to, I don't know, we've got some extra time for questions, and I think there were questions. You want to come on up? Does anybody in the room have questions about issues with remote working that we have not addressed? If you do, go ahead and write them down, and Rachel will collect them. I know Tiffany has already received one from.
So one of the questions we received is, could these same rules apply to a nonprofit C4 and C6? And I think that's maybe referring to the localization test of trying to determine whether or not you have to pay unemployment taxes into certain jurisdictions where you have remote employees. That could apply. I think that there's some more analysis that needs to be done into the nature of what the businesses are doing as to whether or not they're required to pay those. So it's possible.
Any other questions here? Okay. Can the employer add metrics for work at home?
I guess by metrics, I'm assuming you're talking about some sort of performance goals or something in order to hold them accountable, as Jen had mentioned before. And I think that's perfectly suitable. I don't see that as being any different than giving somebody a performance review or something else where you may be giving them projects, you're giving them certain deadlines to meet certain goals of those projects. I think that's a great way to be able to monitor productivity and also.
Yeah, absolutely. As long as they're consistently applied and fairly neutral, so that it's not going to have an effect on one group versus another, I think you're fine. As Peter was talking about the differences in different jurisdictions, even in California, I remember, because I had this issue just with investigations. If you have a client that has an employee that complains of harassment or discrimination in California, the way you conduct an investigation there is different than you have to here. Because of the requirements. So again, it just goes back to all of your policies, making sure you're meeting all of the different requirements in different jurisdictions.
Another question we just received is, are non-exempt employees able to telework? And this is one of those that this is going to be dependent on the employer's policy. There is no prohibition against it, but the thing that you have to keep in mind is monitoring the hours that they're actually working and making sure that they're reporting those hours, because then you may run into issues with overtime and other things where they're working hours outside of what has been defined in maybe the agreement you reached for telework hours, and they're getting into overtime that's not approved or something to that extent. But there is no prohibition against allowing them to telework.
Would change a lot of cases in the file in the reports. So we sometimes get a heads up on who gets who where. And we're told what the cases are. It used to blur. And claims in the Fair Labor Standards Act used to be fairly rare. They now run 7 out of 10. About 70% of the cases you get filed at Fair Labor Standards Act. There's a whole industry of them outside the DC Beltway that will look and find anybody who's got an employee who's misclassified or who's working extra hours. So if you're thinking of doing a remote work agreement with a non-exempt employee, talk to an attorney and get it structured so that you know what you're walking into, because they always end up with, oh, I worked a lot harder. I was working until 11 o'clock at night. And the employee can leave their computer on and be off watching TV. So be very, very, very careful.
So yes, the answer is yes, it can be, but you're going to want to make sure your agreement covers those issues. And I would say in similar situation that if they were going to be working past the core hours, they would have to get advance notice, documented, and approval. And that way, if they tried to claim it later, at least you would have the absence of that, assuming that they didn't get that approval. Okay, here the last question is, it was suggested that unscheduled telework could be granted in the case of mild illness, but how would that be fairly determined? And you know, there's not going to be a bright line test for that. What I was saying is, if someone, obviously if someone's hospitalized, that is probably going to be somewhat determinative, unless of course they're on bed, let's say it's bed rest for maternity leave, or they haven't had the baby yet, so they can actually work there. So part of it might be you need a doctor's note if it's going to be a long-term issue. If it's short-term and the employee has a cold or has the flu but still can work, you're not necessarily going to ding them and say, no, you have to take sick leave. If the real reason they're not working is because they don't want to spread germs. But if it's a serious issue and they really can't work, or they should be on medical leave, that's going to be something that you're dealing with either as an accommodation request or through FMLA leave.
Let me add one thing to that. As a client who has sick leave policy and paid leave policy, and the problem that they have is with exempt employees who can work telework when they want to. Nobody's taking sick leave, and they're accruing it and rolling it over. And then the policy sometimes comes out, and they're doing the same thing with PTO. And it's created a real cultural problem because within different departments they treat it differently. So now they're going to a standard to how you're going to apply sick leave against policy, largely because they're changing their HR system, their entire HR system. But if you're going to do that, you're going to have to realize that the people are going to say, I think I'm going to work from home, but I'm not taking sick leave. So they got this bank of sick leave that they use somewhere to. So just keep that in mind as a precaution.
Very good point. So I think we're just about out of time. Have you gotten any more questions in? Okay.
Any other questions here in the room?
All right. Well, thank you very much for attending. If you have any follow-up questions, our information should be on the last page. Here's how you can get your SHRM and HRCI credits. We'll leave that up for a minute. And it should be on your handouts if you're here in person. And then if you have any questions in the future, you can always contact us.
Especially if there are questions that relate to specific jurisdictions, because this was meant to be more of a general overview. So if you have questions related to a specific jurisdiction, feel free to email one of us or all of us, and we can get back to you on that.
Yeah, don't call because phones aren't working.
Today.
Okay.
Thank you very much.
Thank you.
Yes.